Good evening, everyone. It's very nice to see you. Thank you for joining us for part two of this impaired driving series with the one and only Kyla Lee. Everybody knows who Kyla Lee is. She seems to be surprised about who she is, but we all know Kyla, a Wicked member, and of course, she is known for having a niche in impaired driving cases. We had part one last week where Kyla focused her presentation on charter issues, the common charter issues that we encounter in impaired driving cases. And she gave us a lot of case law and references that were really very useful. The slides and the recording should be available now to people who registered. You should have received that. If you did not receive them, just let the WiCCD team know and we'll send those materials to you. These sessions are being recorded and every session counts for 1 hour of substantive CPD hours. Um, this week's presentation, Kyla will be focusing on defenses other than charter defenses. So those are the more difficult ones in impaired driving cases and where extra knowledge and expertise is required. And this is why Kyla is here for the rescue. So I know some people are still logging in, but we don't have too much time. We only have 1 hour of Kyla's time. So Kyla, I will let you go ahead and start the presentation. Thank you for being with us tonight again.
Thank you, and hello, everybody. Thank you to everybody whose names and or faces that I see who is back for another week of me. Very kind. I'm just going to share my screen because I have a working PowerPoint this time. So today we're talking about attacking the instrument, attacking the readings, all of the things that you can do if you run out of charter defenses. Obviously, I'm going to get a little bit into something that kind of brushes up on charter defenses, just very briefly. Just the first thing I'm going to go through is with respect to attacking ASDs on their actual operation and reliability. That's going to get you to a charter issue on a Section 8 grounds to rely on it. But it's also relevant to refusal cases. And I don't think I talked enough about refusal cases last week. And refusal cases are ones where oftentimes if your client is making attempts to blow and it's not successful, you're going to have a good understanding of how the device or the instrument, depending on what they are alleged to have refused to comply with, works in order to make out that defense. These are also, though, probably the easiest of the cases to attack for machine reliability or functioning. And that's because, and I'll get to it later in the presentation, but there's a very recent decision from Ontario that basically says that the repeal of an old section of the criminal code that happened at the same time as Bill C-46 back in December 2018 means that now the defense only has to raise an air of reality to a reasonable excuse, and then it falls to the Crown to disprove that beyond a reasonable doubt. So that's an excellent decision for us. And definitely one that helps when you can raise some air of reality through a problem with some status messages on either an approved screening device or an approved instrument. So this is a case I mentioned last week, McGuire out of Yukon, that talk about how if you're going to attack the officer's reliance on the ASDs, you look at objective facts that were known to or ought to have been known to the officer at the time that make it unreasonable to rely on the result to invalidate the grounds. And so when you're looking at attacking the reliability of an ASD, whether it's in a case where your client's attempting to blow and is alleged to have refused, or whether it's a case where you're trying to get rid of those grounds, you really want to look at the status messages. In all of the training manuals for all of the ASDs, and I'm most familiar with the Alka-Sensor FST. I know that that's used in most places in Canada. I don't think it's used in Ontario. I think you guys have like a dragger usually. Yes. I do have one, but not the current one. I have the older model that used to be used before the current one. But it's all the training manuals all say the same thing, which is that the officers should be noting the status messages that appear on the device during the testing attempts. They should be writing that down because the status messages can tell you a lot about whether it's a device issue or whether it's a person issue or whether it's an operator issue with respect to assessing it. So this is the Alka-Sensor FST. You're going to have 4 possible status messages on an unsuccessful attempt to blow. if the person puts some air into the device. Those are flow INS, flow low, flow cut, flow high. And then there'll be a third sequence or a third series will end in a blow void reading, and that will appear. So you want to know the status messages for whatever device it is the officer used in your case. And the manuals are easy to get. They're in every law library. They're supposed to be.
Hello, Ed.
Sorry.
Ben correct.
If you can please mute yourselves and I'll...
No, all good. Je t'avais laissé un message.
I think it's
yeah.
Oh, okay,
I'm
she's
muting.
muted.
Yeah.
Okay.
Sorry, Kyla.
No, that's okay. At least it wasn't a question for me. So just find the manuals in the law library, or if you don't have them, make the Crown give them to you. Or you can also do what we do, which is just FOI them from the RCMP or from your police force. If you get it by way of FOI, then you have it forever and you can always use it. That's what we do. That's how we get them. And then we get to know what all of the status messages are. And you want to look for other types of readings. So one thing that's going to be pretty consistent across most types of device, whether it's approved instruments or approved screening devices, is going to be an RFI void. So all of these devices are designed to be immune to radio frequency interference, but they actually aren't. And so they have this detector in them that will detect when there is interference from like your cell phone signal or Wi-Fi or satellites or radios. And this comes from the days when they used to use the Alcometer SL2, which was the first ASD used in Canada. And officers discovered that if they keyed their radio, like their radio that they would wear on their shoulder at the same time that they were administering the test, it would automatically light up for a red alert to fail. And so they were doing that to get people to fail. So that's why we have the RFI void status message now on the modern devices. Is it's supposed to detect when this happens. And chances are it's probably not going to interfere with the results between you and me. But the training is that they have to take certain steps once they get those status messages. And I have one time, I think, that I can think of where I've seen an RFI reading appear. Only one time have I seen the officers actually go, uh-oh, there's radio frequency interference. I need to turn my radio off or find a cell phone and remove it. Usually they're not doing that. So if you get an RFI, whether it's at the detachment or whether it's on an approved screening device, and the officer doesn't do anything, that's a big concern with the reliability of the result, because their training is not just that they get the reading and that it's warned that RFI is a problem. Their training is also that they address the problem and they eliminate it. The other thing that you can get with roadside screening devices, and this can also happen on the instrument at the detachment, is a failed blank check. So the roadside screening devices, at least the ones we use in BC, and I'm sure the Ontario ones have a similar thing where they do a blank check before taking a sample to make sure that there's no alcohol remaining on the fuel cell. Sometimes alcohol can build up inside the mouthpiece, especially if your client takes lots of attempts to blow. You can get a buildup of alcohol in the condensation on the interior of the mouthpiece, which is why they're recommended to change it every 3 attempts. But again, often they don't do it. Each of those mouthpieces costs 25 cents and got to conserve resources. So they will sometimes get a null fail reading, which is the device detecting the ethanol that's either in the mouthpiece or built up on the fuel cell that hasn't eliminated yet since the last person blew into the device. And if you have a failed blank check, that could also signal, however, a problem with the device's ability to actually purge. If you're dealing with an instrument at the detachment, it's supposed to purge the sample chamber to eliminate any remaining alcohol. That would suggest a failure of the purge system. Or if you have a failed blank check roadside, it could suggest that the device is getting phantom readings of alcohol that's not actually there. And that can happen because the chemical fuel cell, and this is what's used in pretty much all of the devices and approved instruments, is just an electrochemical fuel cell. So it's like a battery coated in black platinum and hydrochloric acid. And the when you provide a breath sample into it, what happens is a solenoid engages and it draws a very tiny amount of the breath. So you're going to blow your 1.2 liters of air into the device or instrument, and then it's going to pull out less than a milliliter of air at the end of the expiration of flow. So they're going to look for a drop in your flow pressure, and then that solenoid's going to engage, and it's going to pull a little tiny amount of alcohol onto the fuel cell where it oxidizes, producing an electrochemical reaction that generates an electrical current. And the strength of the electrical current is correlated to the amount of alcohol in the sample. But of course, like with any electronic, you can have a malfunction where it can short out or anything else can react on it. And I mean, not anything else, but anything that is reactive to that can also produce a current. And so a failed blank check may indicate a short or an electrical problem with the device that could lead to a problematic reading. So again, check your manual for what the steps are that the officer is supposed to do if they get a non-zero blank, or a null fail is what status message they get for it in BC, because that can really show potentially that there's a problem, especially if the officer doesn't do the next step and do anything to rule that out. There's of course all sorts of other external issues that can affect the device. Objects in the mouth require a waiting period. The manufacturer's training for all roadside screening devices is going to be 5-minute waiting period for any object in the mouth. And the reason for this is because of breath temperature. So what happens when you're providing that breath sample and you're producing that electrical current is it's not measuring alcohol in your blood, obviously. It's measuring alcohol in your breath, and then it's correlating a breath alcohol reading to a blood alcohol reading. And it uses a principle called Henry's law. This is a lot of science. I'm sorry. You're getting big science lecture today. It uses a principle called Henry's law. And Henry's law states that at a given temperature, the saturated vapor above a solution contains a concentration of solute proportional to the concentration of solute in the solution. Like, to think about it simply, if you put a pot of salt water from the sea onto the stove and boil it at some temperature, and I don't know what it is for salt water, but at some temperature, there is going to be a proportional amount of salt in the steam coming off your boiling or heated water as there is in the water. And so for your breath to blood alcohol ratio, we use in Canada a partition ratio of 2,100 parts of deep lung air is equivalent to 1 liter or 1 milliliter of blood. And so that's your 2,100 to 1 partition ratio. When you change the temperature, you change the result. And so that's going to be important because that can affect anything. Anything in the mouth is going to create issues with temperature. You put something cold in your mouth, it's going to lower your mouth temperature, and you're going to get a lower reading, which is great. Don't bring that up if that happens. Anything hot in the mouth. Your client's pulled over, they're drinking a hot coffee, they had some warm water in their car, it's a hot day, and they left a can of pop in their car while they were at the beach and they were drinking it while waiting in line at the roadblock. Anything hot is going to elevate your mouth temperature. Another thing that can elevate your mouth temperature is having a fever. So if your client is sick, if they have the flu, or even if they have, like, there's lots of autoimmune conditions that people can have that can cause you to have fevers, that can elevate the reading beyond what it actually is. And this is even reflected in the manual, that the temperature of the mouth is reflective of what the breath alcohol reading is. So this is why when there's an object in the mouth, they're trained to wait for any non-alcohol containing object 5 minutes to allow your mouth temperature to stabilize before taking a sample. So if the person has like chewing gum or candy that doesn't contain alcohol, it's still an issue because it can affect the mouth temperature. And you can get most of this out of the officer in cross because they are trained on this. You got to take them back to the manual because they're not going to remember it, and you really got to pin them down to it. But it is something that can affect the roadside screening device. And it can also, like, obviously you're not going to likely have anything in the mouth within 15 minutes of the test if they're doing a proper observation period at the detachment, but you could still have a client with a fever, which is why the officers are trained to ask, are you injured, ill, or on any medication? And, you know, oftentimes your client is too sort of confused, we'll say, to answer truthfully, but sometimes they will say yes, and the officer doesn't follow up to try and figure out what they are, injured, ill, or on medication. And if they are, what is it, and whether it's causing elevated mouth temperature, which would rule them out as a candidate for proper breath testing. And they would not consider that. I've never seen an officer go, oh, you're sick. Oh, you have COVID. Oh yeah, we can't take this test because you probably have a fever, or I'm going to take your temperature first to make sure that you can take the test. I mean, obviously I would tell my clients to refuse having their temperature taken because it's hard to reach, but um, these are all sorts of other things that can affect both the roadside and the instrument of detachment: smoking, vaping, mouth alcohol from recent consumption, alcohol containing products, burping, belching, vomiting, regurgitation. Also weird stuff like bananas. So bananas, what makes bananas ripen is a certain chemical, and that chemical can register as a false positive for alcohol. It's a metabolite of alcohol. And so if you eat a banana and then you blow into a breathalyzer, you will get a reading, which is kind of freaky. Lots of bread products too, very yeasty breads. Like I did this video once where I ate hot cross buns just in time for Easter and then blew into a breathalyzer and got a reading just from a hot cross bun. Mouthwash, oral hygiene products. I did one recently where I put like Oragel, that gel that you put on the inside of your gums when you have a toothache. That produces a reading. There's ethanol in that. And perfumes and colognes, even if you don't ingest them, wearing them, they contain, most perfume and most cologne contain ethanol as an ingredient. And the vapor coming off the perfume or cologne, especially if it's been recently used, can be detected on the device. I didn't put on here hand sanitizer, but that's another one where if hand sanitizer has been recently used, the hand sanitizer vapor can be basically inhaled and then exhaled directly into the device. And so you can get a false reading just from using hand sanitizer. So there are scientific studies on this that have found that there needs to be a full 15-minute waiting period from any time somebody uses hand sanitizer before operating the device. So when you are looking at your videos, if you look at your roadside videos, look to see if the officer cleans their hands at all before they touch the device. They might do that, especially after COVID. People are more cautious about that. Or if you have a case that's still from 2020 for some reason, or an older case where somebody absconded and has recently been caught, look for the officer using hand sanitizer. At the detachment, watch the detachment video, watch them in the breath test room, see if they're cleaning the countertop with anything, see if they're cleaning their hands before they unwrap the mouthpiece or put it on the instrument. Because if they're doing any of those things, then that can lead to a false reading on the device or instrument and give you a basis to challenge it.
Kyla, before you move
Yeah.
on, just because I see there's already a question in the chat and it's actually relevant to what you're talking about right now. And the question is, have you litigated the issue of any interaction of vapes with readings?
Yes, I haven't litigated it in trial. I have done it in like our BC immediate roadside prohibition hearings. And so I have argued it successfully in those, and I just opened the chat and now I have to just exit out here to close that. So sorry about that. And it's difficult. Vaping is difficult because this is a study, and if you want the study, if you have a vape case, email me because I'll send you the study. There was a company in the US that decided to take 55 different vapes, and they took the ingredients out of the vapes and they ran them through headspace gas chromatography and mass spectrometry to determine what was actually in the vape juice. And of those 55 vapes, 35 out of 55 contained ethanol, but did not list it. So and they actually have a table with the manufacturers and the names of all the vapes, so you can identify which ones have undetected ethanol. And then you're going to need an expert obviously for that, but you'll have a scientific foundation. So I have successfully argued the vaping issue in cases either where my client gets evidence of the ingredients of the vape showing that it contains ethanol, or where it's one of those listed ones. But in a criminal case, of course, you just have to raise a reasonable doubt. So you could, through an expert or through the Crown's qualified technician, even if they're testifying, you can put in that evidence of the vaping study and ask them about the impact of vaping. So yes, vaping, I have won it on the administrative level. I haven't had a criminal case where they've been vaping yet, but time will tell. The approved instrument I'm not going to lie, it is really hard now with the way the criminal code has changed and with the limited disclosure that we get and with the technological advances on these instruments to find actual evidence of malfunction. I have seen it in only a handful of cases. Most of the time, you're going to get what you're used to seeing in every case. You're going to get a breath test ticket. You're going to get printout from the instrument that's the certificate of qualified technician, or one that's completed by the officer independently of the instrument. In any INTOX ECIR2 jurisdiction, the instrument will print it out automatically. Outside of the ECIR2, I don't know. I think the Datamaster DMT has a printer. I'm sure the Intoxilizer 9000 does. But you're going to get your breath test ticket as well as this other information. And it's often there where if there's going to be evidence of a malfunction, you're going to get it. And if you don't see anything on those documents, the likelihood of you being able to bring a disclosure application to get further disclosure is pretty slim, because unless you have some actual evidence to show that it's more than a fishing expedition, you're going to get shut down, kind of following the Supreme Court of Canada's decision in Govans. So I always think look at the tickets and the certificates first to look for malfunctions. So again, first thing you always do anytime you're up against an instrument is get the manual. And I like to get both the manufacturer's manual as well as the police or RCMP manual, because sometimes they conveniently omit important information that you might want to know. And you can rely on the manufacturer's manual to sort of open a few more doors than what is in the police manual. You're going to want to review any status messages for any unsuccessful attempts. That's one thing, like with the INTOX ECIR2, if there are unsuccessful attempts, there'll be a status message that appears on the scrolling screen on the instrument, but what's printed on the breath test ticket is nothing unless there were 3 of those messages, and then you get 3 stars. You don't actually get the status messages. Arguably, and I haven't gotten to the point, unfortunately, I've had all my samples excluded in cases where I've wanted to argue this, but arguably that's a violation of the obligations in 320.34, sub 4 of the code. But oftentimes officers, the qualified technician or the investigating officer, if they are a QT, will record it in their notes. So always check the officer's notes as well for what they say was happening. And review them and make sure that what they're saying or what's printed on the ticket, depending on your instrument, actually matches what's in the manual. Because if it doesn't match, it's evidence of a malfunction or an error with the instrument or an operator error. And again, officers are trained, especially the qualified technicians, are trained to document any unusual messages in their notes. Now, do you guys have the Datamaster DMT in Ontario? I got to use it when I was in Ontario one time. I don't see anybody nodding their head yes. If you ever get a case with a Datamaster DMT, this thing is cool. You can actually see on the screen the airflow, the graph of the air as your sample's going in, and then what it's measuring the alcohol, and as the alcohol tapers off as your airflow decreases. And I got to use one once. I won't tell you how because I wasn't supposed to, but I was able to trick it into accepting a sample that had mouth alcohol by regulating how much air I was providing into it. So you really want to look at that graph. What you're looking for, if you get a graph of the airflow ever, is you're looking for a pretty initial, like steep incline, like the side of a hill if a child was drawing an upside down V-shaped mountain. And then you're going to want like a gradual plateau, like half of a parabola down. That's what you're going to be looking for, a steep incline, half of a parabola down. If it doesn't look like that, there's probably an issue either with the instrument or with the person who's blowing, not properly regulating their breath and providing a sample that's consistent, that is actually going to prevent the instrument from looking for the things it's supposed to look for to see if there's a problem. So this is what you're entitled to under the criminal code. And you should make sure that you have these. These are all things that are usually documented in the certificate. And I say that with air quotes because they're not really documented in the certificate. They're just a bunch of promises that these things actually happened. So the results of the blank tests, your certificate will always say that the result of the blank checks was 0. But it's not always 0. And a lot of the instruments, the Intox CCIR2 especially, run a non-zero blank. So they do a masking for anything on the blank that is, depending on where you're using it, 4 to 9 milligrams of alcohol and 100 milliliters of blood. So if you get a case that's like an 80 case or a 90 case, you might actually have somebody who is under, or if you get like an under 80 where they're trying to extrapolate back, you might have somebody who's under 80 because they've had a non-zero blank. And I tried to run this in an 80-80 case in Alberta one time and try to bring a constitutional challenge to the Crown's failure to preserve the actual results of the blank checks. But some tickets will actually disclose what the blank was, but usually you're going to get a masking for anything less than 4 to 10 or 4 to 9 milligrams of alcohol and 100 milliliters of blood. So if you see anything that's not a true 0 on that breath test ticket, that's a problem because A, the masking has failed, and B, it's not a blank check that was 0 and it's not consistent with the code. So look at your blank check results. Don't just read the face of the certificate, but also go to the ticket and make sure that each single one of those blanks, and there's going to be multiple blanks, there's going to be a blank before the alcohol standard, after the alcohol standard, before the sample, and after the sample again to make sure that it's purged all of the alcohol from the instrument. And if there's non-zero blanks, it can also indicate, again, purging errors where it's not purging alcohol that's been left over from the sample, or where it's not purging alcohol that's been left over from the standard. And all of that's going to have an additive effect. So whatever's not being masked plus whatever's left over there is going to add to the actual sample reading. The results of the calibration checks. It'll always say there were, before each sample, I did a calibration check which passed or something to that effect on the certificate. Look at the ticket, make sure that they did say passed. The sample is not supposed to proceed if it doesn't pass, but again, because these are electrical equipments, just like your phone is not supposed to do all sorts of things it messes up on all the time, or your car is not supposed to do all sorts of things it messes up on all the time, doesn't mean it's actually going to work. The errors or exceptions, exception messages produced by the instrument. This is why I say anytime where they don't record what the device or instrument actually said when your client was blowing into it and not successful in providing a sample, but then later get a reading of 180 or whatever. If you don't have those specific errors or exception messages, that's a violation. Those are things that you're entitled to under 320.34 sub 1. And if they fail to preserve them, arguably, the certificate is inadmissible. And arguably, the readings are inadmissible. The other thing, the results of the breath samples, there's a number of things that happen with breath samples. Check to see if they're supposed to be truncated. I'm pretty sure most places in Canada are doing truncating. I know it happens in BC, Alberta, Saskatchewan, Yukon, Northwest Territory, Nova Scotia. Trying to think where I've done, and I only had a blood case in Ontario. So, but everywhere I've done one, they truncate the readings. So what happens is they round it down to the nearest lowest multiple of 10. So if you blow 187, it's going to be rounded down to 180. And it's always rounded down from like the multiple of 10 to the lower one, rather than rounding up ever to give the benefit to the accused. But I have seen cases where the instrument actually doesn't truncate the readings. I had a case where this happened in Castlegar of all places, and it was really weird. The instrument produced a certificate, everything looked fine, but the readings were like 167, 163, which made no sense because truncation is part of the way the instrument is set up in British Columbia. And so brought it to the attention of the Crown. They had a Crown I could trust. And, what are you going to do? Fix the readings that are gone forever now? Brought it to the attention of the Crown. The Crown looked into it. They looked into the records on the instrument. And turns out when the instrument had been given its annual servicing, they left it in calibration mode. So it was not giving accurate readings because every time somebody blew, it was recalibrating itself against whatever the last person blew. And it was not truncating because it was supposed to be giving an exact reading because it was in calibration mode. So it was really bad. So look for that because that can be evidence of a malfunction where you're looking at it and you're like, cool, I've got like an exact reading for a change, but turns out that's actually an operator error in the calibration process. And who knows how many people blew into that instrument before my client, who then probably had their charges stayed. I didn't follow up on the other people. I feel bad. And then look at the samples and make sure they agree within 20 milligrams percent. If you get a 160 and then a 200, that's a concern. A 160 and a 190, that's a concern. And when they don't agree within 20 milligrams percent, the police training, of course, is to just take another sample, to just take another one after another 15-minute observation period. But they never look into why the readings didn't agree. And if you have, like, you can argue successfully. Usually this is an argument you make to the Crown, but you can argue successfully with the an expert witness assistance in court that if you have a reading that's like 150 and then you get a 180 and then the next reading they get is 140, that doesn't make any sense because there's no way that a person can go from 150, absorb 30 milligrams of alcohol. I mean, that theoretically could happen in the 15 minutes because absorption can be very rapid. And then eliminate 40 milligrams of alcohol. And just because two of them agree doesn't mean that the middle one or the outside number that didn't agree within 20 should be ignored, right? It's still evidence that raises a question of what happened here. And there's lots of things that you can do with that. You can say if they don't agree within 20, put your client on the stand if they were burping or regurgitating or they have acid reflux or something like that, and raise a mouth alcohol concern that the officer wasn't paying proper attention to. And that might get you over the hurdle that we'll discuss in Sur Langlois for raising sort of real evidence of an error in order to satisfy that obligation. And then the last thing that I always take a very close look at is the certificate of analyst for the alcohol standard, because that can have there can be tons of defenses that arise out of an alcohol standard certificate. So on our roadside prohibition schemes in BC, for a period of time, a very glorious, probably 8-month long period before the government found a fix, I was winning every single case I argued. Like I won 100 cases in 1 month. And using this in criminal cases to basically get every criminal case resolved. Alcohol standards that are gas standards, this is a wet bath one pictured here, but a gas standard is a canister of gas. It's manufactured, it has alcohol. Most of the instruments use gas standards now because they're cheaper and they last longer. And they don't, you have to replace those solution after 15 uses and it can be quite expensive to go through it. So they use the alcohol standard in the gas form. Because you can get like hundreds of blows out of a single one. They have an expiry date that's 2 years from the date of manufacture. But I managed to get a bunch of records from various police detachments in various files that I had, all of which showed different dates of expiry for the same lot of alcohol standards. You're going to have a lot number, and that lot number is only going to have one expiry date, which is going to be 2 years from the date of manufacture. So keep a chart on all your impaireds of the lot number of the alcohol standard, the expiry date, the lot number, the expiry date, and go back and compare and see if there's any other cases you've had where you had an alcohol standard that had a different expiry date for that same lot number, because that would be a problem. And then look at your certificates of analyst. Your alcohol standard expiry date is going to be listed, supposed to be listed on the certificate of analyst. That was one of the fixes the government came up with. And it's and compare, make sure that those two match up. You're going to look at the one on the certificate, you're going to look at the one on the tickets, and you're going to look at the one on the certificate of analyst for the alcohol standard and make sure all three align. They're all going to be printed there. All the lot numbers should align. There are tons of cases where there have been discrepancies in the lot numbers because they were not properly entered into the approved instrument. Nobody caught it. Expiry date wasn't properly entered into the approved instrument, which is a big problem because the instrument is the one monitoring the expiry date. So if the expiry date passes, but it's actually written wrong, the instrument will never know, right? It is a piece of technology. It relies solely on human input, just like AI, right? AI only knows what humans tell it. And it's not going to just magically know the correct expiry date. So I always make sure all of these align. And you would not believe the number of times there is some sort of a discrepancy on these things. Also make sure that all of the dates align. I have had a shocking number of cases where the date of service of a certificate of analyst, which is usually given at the same time as the certificate of qualified technician when the person served at the end of the investigation, the date of service is different than the date of the investigation, like by months or years, or they write the client's name like not his name. Same with the certificate of qualified technician. I've had them write the wrong client name on it, misspell the client's name, misspell their own name. I mean, these are police officers, right? We're not dealing with geniuses. And so I always double check all three of those documents line by line for each point against each other to make sure that everything lines up, because as soon as you get one discrepancy, you're into that reasonable doubt territory. Lots of case law on these issues. That tiny file just meant to emphasize this. So there is a divergence in law in Canada, in appellate authority, on whether or not that certificate of analyst for the alcohol standard has to be filed, as in somebody has to bring it to court and file it as a document in the trial. In Alberta, Goldson says, yes, that has to be done. In Yukon, McDonald says, no, that doesn't have to be done. And different provinces follow them differently. I didn't do a deep dive, sorry, into every province. BC hasn't considered it. They considered Goldson in a provincial court case. I know that, but it's never been considered at the appellate level. So if you're in a jurisdiction where there is no appellate authority on whether Goldson or McDonald prevails, or your only appellate authority is pre-McDonald, then you can rely on Goldson. And you should rely on Goldson. They have to file that document and they have to bring it to court. And like all of the other certificates, they have to give you reasonable notice that it will be adduced in court. Certificate defenses are still great defenses in impaired driving cases. A lot of people say that the amendments to the code have basically killed the certificate defense. They've just made it harder. We're now back to like 1973 and litigating what constitutes reasonable notice. And I'm not joking when I say that. Like the last argument that I made on reasonable notice, half of my casebook was cases from the 70s. But I won, so there you go. A lot of people will confuse reasonable notice with the statutory timelines in the criminal code, but the case law hasn't evolved that way. The case law has basically said that reasonable notice depends on all of the circumstances. So you have to, or the Crown has to provide you with the documents with reasonable notice of their intention to produce them at trial. But if you want to cross-examine the person who prepared the certificate, whether it's the analyst from the lab who did the analysis of the alcohol standard, like, for example, you get a multiple expiry date or a multiple lot number with the same expiry date situation, or you have a qualified technician that you want to cross-examine on some mistake in the certificate, then you need a minimum of 60 days to accomplish that, because you have to provide under 320.34 sub 4 an application to cross-examine or an application for further disclosure 30 days in advance of trial on 30 days notice to the Crown. So you're looking at a 60-day minimum for you to bring this application. And that's annoying. But if you get the documents less than 60 days, guess what? The criminal code doesn't give any power to a judge to abridge any of the timelines. So you can say, sorry, judge, you don't have the ability to shorten these timelines. So I need an adjournment because the Crown didn't serve this to me with enough time for me to bring my application. And I have a good faith basis for this application. Better find one. If you're going to need one. If you get this less than 60 days, bring an application for an adjournment, or say, we're going to have to hear the Crown's case and then adjourn the defense case, because then you're going to get into Jordan territory. So, or maybe you won't. I don't know. With your Ontario rule, you're probably not, because you're going to have all your trials within 6 months somehow miraculously, despite the shortage of judges and courtrooms. But bring your application to adjourn and find a reason to apply to cross-examine. Because if you derail it and there's delay, that delay falls at the feet of the Crown because they knew, right? This evidence was generated on the day of the offense. They had every opportunity, the certificate of analyst, before the date of the offense. They had every opportunity to serve it to you. They knew under the law that you were entitled to a copy of it. You're entitled to those two things under the criminal code. So their lateness prejudices your client's ability to bring that application. That is clearly Crown delay. So reasonable notice arguments are great if you have nothing better than creating delay. And reasonable notice arguments are also great because even if you don't end up adjourning, you can object to the admissibility of the document as soon as the Crown intends to file it. I'm sorry, Your Honor. I'm going to object to the admissibility of the document. The Crown has not failed to establish that there was reasonable notice provided for its admissibility. And then you can get into an argument on whether or not it's admissible. And oftentimes it will be ruled inadmissible, especially if it's coming late in the day. I think the one I won was like 49 days before trial. And I said, I want to cross-examine the analyst because I had all my like certificate evidence. This was 2020, back in the day. So I still had all this evidence of problems with certificates and there was incomplete information. And yeah, the judge threw out the certificate and my client walked and it was a lovely day for him. Certificate errors that I see very commonly. The person is, it says certified, I should have said designated. The person's supposed to be designated by the Attorney General, but which Attorney General? They get this wrong so often. Oftentimes they're filling out the certificate and they're saying they're designated by the Attorney General of Canada. And that would be great if they were in the territories. But if you're not in a territory, then it's designated by the Attorney General of the province. So if you're in a province, Attorney General of whatever province you're in. If you're in a territory, Attorney General of Canada, not the Attorney General of Yukon or anything like that. So look at that location, make sure that's correct. So often it's wrong. Also make sure that your officer completed their recertification. You can ask the Crown to produce this information. It falls outside the scope of, in my opinion, a disclosure application because it's not asking like the 320.34 disclosure application because it's not asking for something that is disclosable related to the instrument or its functioning. It's asking for the qualifications of a person who operated the instrument who says that they're qualified, and you should be entitled to have that information. I've never had Crown put up a stink about turning over recertification. It's supposed to happen every 2 years. Half the time it's not. Always still, you can argue true and accurate certificates copied and compared. All those old things have not been written out of the criminal code. I had a judge recently in a criminal case say to me, isn't that dead now? And I said, no. He said, well, in my mind, it's dead. And I said, well, I'm sure it's great to hear that you're prejudging this, but I'm going to argue it. And then I argued it and he had to rule on it. And it's not dead. There's no case law that I'm aware of, certainly not in British Columbia or Alberta or Yukon, that says that they don't have to engage in copying and comparing. And when making that argument, I looked specifically for any case law that suggests that they don't have to serve a true and accurate copy. And if you go back to the 1970s, the reason for a true and accurate copy is because the certificate is supposed to answer all of the questions, statutory or common law, as the case may be, all of the questions on the four corners of the document. So it has to be the same. Names, dates, and times. You want to ensure consistency with these. There are weird things that happen that I cannot explain other than malfunction or error, where dates and times on the certificates are not correct, like even close to correct. I don't know how it happens or why it happens, but I have seen it in multiple cases. I especially see it in blood cases because those certificates are prepared by the analysts at the lab, and I don't think they're paying as close attention to it. And also look at the version of the certificate. The Intox CCIR2s in BC, and I don't know about other provinces, still print out the old form of the certificate from pre-December 2018. So I still get that disclosed in every file. And in any case where the qualified technician signs that document, they've just certified that there was a demand made under 254 of the criminal code and that they're a qualified technician designated under section 258 and that they used an alcohol standard certified by an analyst under section 258. Those are not sections that exist. They were all repealed, but they certify it. And then you can apply to cross-examine the qualified technician on the basis of inconsistent statements and just destroy their credibility, that they're just blindly signing off on documents without regard for the contents of that document, contrary to their training, because they know this form shouldn't be used. And if you didn't follow that training, then we don't know what other training you didn't do correctly. And we can't trust anything you say in this other certificate because you're just nodding your head, borrow the language of Araujo on warrants, to a stock checklist of suggested favorable facts in a template as opposed to the actual facts of the test that you conducted. And you can destroy their credibility that way. Then you've got sample errors. One thing that the detachment instruments do that the roadside ones don't is have mouth alcohol detection, but it is not perfect. If you are using an Intox ECIR2, there are reported cases out of the US where there was evidence discovered by US lawyers who can get pretty much everything you could imagine. They can get the source code. The mouth alcohol detection system in the Intox ECIR2 detected phantom alcohol that didn't exist. That's the electrical currents, magically detecting electrical currents that don't exist. And so mouth alcohol or invalid sample can be an indication of maybe your client burped while they were blowing, but it can also be an indication of things like alcohol in the room. If you're going to get like an ambient fail, again, it's going to be different language for each instrument, but an ambient alcohol detected status message, that can mean cologne, perfumes, something in the room. In every single case, police officers will say there was just so much alcohol wafting off the accused that it caused the instrument to fail. It doesn't work that way. It doesn't work that way. It is probably hand sanitizer or cologne or perfume or something like that. And remember, it's not just your client who can put cologne or perfume on, it's also the police officer or the cell guards or the civilian employees at the detachment who might have been in the room, or the cleaning people who might have been in the room, right? We're not just dealing with one single possible cause being your client. So again, look at all of that information. And then on the data master, there used to be this thing called the 5-way valve. So this was how the instrument operated. It had a valve inside. It was about this big, and it had a little, like a hole, and then it had a little thing that moved in and out. That's not a very great image for those who just saw that, but this is the only way I could describe it. And then within the thing, it had 5 different holes. This is why it was a 5-way valve. And it would be for the alcohol standards and for the sample and for the exhaust. And what would happen is over time, grime and like bits of food and stuff that got blown into the instrument would build up on the 5-way valve, and there would be corrosion and it would get stuck. And so it would get stuck halfway between 2 positions. And when that happened, it would take alcohol from the alcohol standard and draw it into the sample chamber, which would result in what was at the time an invalid sample reading. That is the type of thing that you're not going to see, other than you're going to get a reading that thinks it's detecting mouth alcohol, or thinks it's a non-zero blank, or thinks it's something else. But what is actually going on is a physical malfunction with the device. And if that happens during the sampling process and it's drawing alcohol from another place, it's not going to rule that out because it's bypassed all of your other mouth alcohol detection filters, which are happening during the blowing phase, and it's getting it at the sampling phase, and it's going to lead to a falsely high reading. Obviously, you're going to need an expert for this. But if you see anything like a mouth alcohol or invalid sample reading, don't just assume that it was because your client burped. It's, in my experience, often more likely that it's something else. And usually you ask your client and they're like, no, I wasn't burping. That didn't happen. So there's no explanation from your client. And you can put your client on the stand, assuming they are, not going to compromise anything else by doing that, to say that they weren't the cause of it, that they weren't burping, that this didn't occur. And then you can point to that as a malfunction because it shouldn't detect alcohol that's not there. Like, it's not supposed to do that. So either it's detecting alcohol that's not there, which means who knows how much alcohol it's adding to the samples, or it's malfunctioning in some way that can affect the samples because it's resulting in a reading showing alcohol. And I already talked about the readings being 20% or more. 2 cases you're going to need to know to make these types of arguments. The first is Santonge-Lamoureux. Basically, this was a constitutional challenge to some earlier amendments to the criminal code, but the language is still the same, which is that in order to raise evidence to the contrary as reasonable doubt, it's not an irrebuttable presumption. Essentially, what you have to do is you have to do what Cyr Langlois says, which is basically show that there is like some actual evidence about a defect or a problem that could, in theory, compromise reliability. So you don't actually have to show that it could compromise reliability. Once you raise that issue, the burden then shifts back to the Crown to prove that it didn't affect the reliability of the sample. And so Cyr Langlois says, paragraph 16, that they don't rule out the possibility that improper operation may be so serious or closely connected to reliability that it will be sufficient itself to raise a reasonable doubt. It doesn't matter whether the possible impact on reliability is inferred from the actual nature of the defect, from the extent of the defect, or from other external circumstances. What is essential is that the possibility that the defect affected the reliability of the results is serious enough to raise a reasonable doubt. So you can't just raise this wasn't supposed to happen. You also have to connect it to reliability, but it just has to be a possibility serious enough. It doesn't have to be a probability even. So you're just in possibility territory. And you can use expert evidence to do that. I would recommend having an expert if you're going to do this for anything other than like maybe burping or regurgitation, where that's not going to be necessarily the subject of expert evidence because everybody's going to agree that burping can cause false results. So here are some external issues that can affect reliability that you can raise. Lots of things you want to canvass with your client. Are they diabetic? Because did you know that if you are in diabetic hypo or hyperglycemia, your body can start to produce ketones, which are developed by the body metabolizing stored fats, and then it gets converted into acetoacetate and acetone and isopropanol, all of which are like volatile organic compounds that can register false positives on fuel cells as alcohol. That's also what happens when you do like a keto diet or intermittent fasting. Obviously, you're going to need evidence from your client about this, that they're following the diet, usually some medical evidence. Get them to go to their doctor and get like a blood glucose, a fasting glucose, an A1C, and test their urine for ketosis if they're saying that this was an issue. Acid reflux or GERD, like you don't have to actively be burping or belching. If you have acid regurgitation, Dr. Wayne Jones, the like granddaddy of all alcohol testing research in the world, who's published in the last time I saw him over 95 peer-reviewed journals. He's very concerned about the impact of acid reflux and GERD, has published extensively on it. He did a study that he regrets where he like put like these lap bands on people and tried to induce it and didn't get readings and said, oh, this isn't a real possibility. And then he realized how stupid his study was because you can't just induce something that's a biological malfunction of a person's body. And he's since studied it some more and realized that this is actually a huge problem. So check with your client if they have acid reflux or GERD. And if they do say they have these symptoms, get them into their doctor, get them scoped, get them to do the gastroscopy, get the doctor to examine their throat for signs of GERD, send them to the dentist because the dentist can see GERD on your teeth. And they can see the impacts of that in your dental work, and so they can say that this is a potential issue. And then you have the external burping, belching, vomiting, regurgitation. You know what to ask your client about that. You can also get longer mouth alcohol retention. Studies have shown up to 35 minutes of mouth alcohol retention. So not going to be ruled out necessarily by a 15-minute face-to-face uninterrupted observation period. A longer than 35-minute mouth alcohol retention for people who have dental appliances, retainers, mouth guards, anything like that. If your client has that, the false tooth, those little bumpers that people wear, things like that, anything like that, a dental implant, anything like that could potentially, dentures could potentially trap mouth alcohol for a longer period of time. Invisalign, that's a big one that's really popular these days. Gum and candies containing alcohol or something that can elevate the mouth temperature, perfume and cologne, we talked about. There's that first case that I mentioned, the Rafea case. I'm probably not pronouncing that correctly. That says that the burden of proving a reasonable excuse is on the defense only to raise an error of reality. Then the Crown has to disprove it. And then there's a couple other cases there that are super helpful for refusal situations. I like Cummins Cummins lost, but the law is well explained in paragraph 15, where it talks about how a reasonable excuse is some circumstance that makes compliant either extremely difficult or likely to involve a substantial health risk. So I like that for cases where the client has like a really bad heart problem and they don't want to blow because they're worried about their heart exploding or whatever. You're like, if you can get some medical evidence to show that it involves a substantial risk, then they don't even have to try, which is cool. That's not going to work for your asthmatics, but asthmatics are going to get into the extremely difficult compliance territory with the right evidence from their doctors about their ability to blow. And then you have a couple other cases there, cognizant of the time. I want to spend a little bit on blood, but the biggest thing I can tell you on blood, the most important thing is don't try and challenge the reliability of a blood sample without your own expert, because the Crohn's expert will walk you around the room and run circles around you. They are well rehearsed, I will say. And this stuff is really hard to understand. So what you're going to have when you look for a blood test result, most of the time you're just going to get your certificate of qualified technician from the lab, where they're like 194 milligrams of alcohol and 100 milliliters of blood or serum or plasma, and then they do the conversion, if it's not whole blood. But you are entitled to the lab file. If you read Gubbins says you're entitled, it's relevant first party disclosure, the analytical results. So I always, in every blood case, I always request the lab file. For whatever reason, they don't proactively disclose it in BC or Alberta or Yukon, but probably not in Ontario either. But I get it, because I put up a fuss. Or bring a disclosure application, which I've had to do, and I've gotten it every time. I don't get everything I want, but I never get everything I want, because I always ask for more than what I want, so that the judge splits the baby and gives me what I want. So what you're going to look for is like unidentified peaks on a chromatogram. So this picture here is like a really simple definition of a chromatogram. It's just peaks. And what is actually measured for alcohol concentration is the area under the peak. You want nice, tall, narrow, thin peaks. That's a beautiful peak. But there's some sort of unidentified peak on that. That's actually probably an injection artifact looking at that, but there's some unidentified peaks. You're going to look for unidentified peaks on the chromatograms. The instruments that the police use only use gas chromatography. They're not using mass spectrometry. So if there's a volatile organic compound and you get a peak and they don't label it as something, the instrument doesn't label it as something, that's an unidentified peak. Sometimes your analyst will handwrite on there what they think that the peak is. That's just a guess. They don't know. The instrument didn't quantify it. It means it wasn't identified as that. They can guess. And they're usually going to guess something like acetone, isopropanol. These are all volatile organic compounds that you see in people who are metabolizing alcohol, but that are also byproducts of degradation, putrefaction, and fermentation. These are all different processes that can happen to a blood sample. Putrefaction is like where it goes bad. Degradation is where the quality of the sample degrades, and fermentation is where you have happy little microbes eating things in the blood sample, and then pooping them out, literally pooping them out as ethanol. And they can even eat ethanol and then poop it out as more ethanol, or poop it out as less ethanol. So you can have a blood vial, and the alcohol concentration in the blood vial can go up and down over time. And the longer the time passes, the more it's going up and down and changing as those microbes do their little microbial thing. So what you want to look for to see if there's any issues with this: when was the sample drawn compared to when it was analyzed? What's the continuity? Can they show that it was refrigerated? Can they show who handled it? How many times was it opened? How many times was it tested? How many times did anything enter there, right? Your hands, 58,000 different bacteria on your hands. Now you all want to wash your hands. 58,000 different bacteria on your hands. You open a cap, a sample, and all of a sudden, all those bacteria are going in there. You look in, you're breathing into it. All of the things in your breath, all of those volatile organic compounds are going into the blood, and then they're engaging in their little microbial action, and it's super gross. And then they're pooping out ethanol as a result of it. So look for things like refrigerated. Look for what medications your clients might have been given at the hospital. That can impact the sample. I had a case recently. I lost it for a variety of reasons, but one of the things that my expert said was that there was a concern about potential clotting of the blood sample because the client was given TXA, tranexamic acid, which is a clotting agent. It promotes clotting, and they were concerned he'd been in, he had bleeding after the motor vehicle collision, so they give him a clotting agent to make sure that he clots so that he doesn't bleed to death. Super normal hospital procedure. But the problem is then they take his blood out and they put it into a non-forensic lavender capped tube. Your forensic tube is going to be gray capped. That's your RCMP blood kit or your police blood kit, gray capped, gray stopper tube. It's going to have 2 preservatives, potassium oxalate, and sodium fluoride. All the other tubes that they use at the hospital, which often get seized by warrant, all those tubes don't contain those 2 preservatives. They have anti-clotting inhibitors, but when you have a clotting promoter and an anti-clotting inhibitor, what happens? They cancel each other out. And so neither works. And there's no preservative in that tube. And you can get clotting over time, which can affect the sample. So look for things like that. Look for the expiry dates of the tubes. The police will always say, oh, it's fine to use non-expired tubes. But guess what? The manufacturer of all the tubes, BD, Becton Dickinson, says, no, you cannot use them past the expiry date. They'll say this only affects the quality of the vacuum. The quality of the vacuum does affect the quality of the sample because the vacuum allows them to draw the correct volume of blood. And if they draw too low of a volume of blood, the analysis can be done improperly. And also, if they Becton Dickinson will say that the preservatives in the tubes can also degrade as they, just like you're not going to take expired medication, right? I mean, like I do, but probably most people are smarter than me. You're not going to take expired medication because it's not as effective. That's what's in the tubes, expired medication, effectively. It's not as effective. And there we go. Okay, I'm 5 minutes over, so I should probably stop and ask if there are any questions. I see 2 people in the chat. Oh, just somebody who said brilliant. And say that a client was aware of this. Have you ever encountered a situation where a subject would intentionally throw the reading by using hand sanitizer prior? Yes, I have had clients deliberately put hand sanitizer on themselves while the police officer walked back to the police car to get the ASD, and they get out their sanitizer and they rub it all over their face. And they think that that's super smart. That has never gone over well for them. So I would discourage my clients from doing that or from trying to raise that defense if they can. So, okay. Any other questions in the room?
And while if people have questions, please ask your questions. But if you can also put your videos on so we can take a picture where we don't see black boxes, that would be really nice. Hi, Kelly. Hi, Bonnie. So before you guys leave, just if we can take a group photo. Just put your videos on just for a few seconds. Here we go. Oh,
Okay.
I think there's a question. Yeah.
Do you have citations of cases we can refer to that highlight problems with the ASD or breathalyzer? I mean, probably like in my library of case law, but it would be dependent on the problem and the device and or instrument. So I guess feel free to email me if you have an issue, and I'll tell you if I have a case that's similar to that. That's probably the best thing to do. Okay, are we all posing?
So, okay, no, but come on, everyone. If you can put your videos on, just so I can take a picture and so that everyone can go then. You see if on the
Got a
second
baby.
page. All right, I think I have everyone whose videos are on. I'm just gonna also take pictures, and by removing, I'll hide the non-video participants. Here we go. All right. So I think we have all our photos now. So thank you so much, Kyla, for this amazing session as well. Part 3 is next week. And part 3 is actually going to be also very important because it will be about the sentencing and the consequences and all the things that we have to think about when have to advise our clients on sentencing if they want to plead guilty or if they're sentenced of what could possibly happen, which is very important in impaired driving cases. So thank you for staying these extra minutes. But this was really very good. And see you all next week. And you will all get copies of the slides and the recording soon for those who registered. So thank you and good night. Good evening, Kyla, for you. I know you're in BC. Bye bye.
Good night, and thank you so much, very
Bye.
much.
Bye.